the SEC and the SIPC. One of the things that I said before is, people need to know that on the website or in the door that SIPC symbol means something. The investor public needs to know that it means something. And if we look back at the original language in SIPC series rules, and there's a federal regulation 300.500, it says the rules provide for the classification of claims in accordance with the, quote, legitimate expectations, close quote, of a customer based upon the written transaction confirmations sent by the broker-dealer to the customer. Seems pretty obvious to me. Did you get a statement? Yes. Was it a reasonable expectation that your statements, one after the other, look like any other statements you got from Merrill Lynch or anybody else? That's right. I think the answer is probably yes. There probably weren't any big signals going the other way. So again, I think this is this set of expectations that you all had in this process. One of the interpretations, I guess I'll ask Ms. Chaitman this question. One of the interpretations the SEC seems to be talking about, based on this lack of precedent, is that there's no case law that really talks about the fact that the interpretation should be that if an investor told a broker to purchase specific securities, that seems to be a very clear case where the SIPC can come in and fund. But if you didn't have that specific line of securities requested, and most of us go into a broker and there's a sort of a risk assessment of, I want some bonds and some this and some growth and everything else, that doesn't seem to be covered. Ms. Chaitman, do you have a thought on what the SEC's view and why that doesn't seem to make sense?
Well, the first I learned of the SEC's position was last evening when I saw their written testimony. And I have to tell this body that there is no authority in the statute for the SEC's position. In other words, you can read SIPA from beginning to end, from the first word to the last word, and nowhere does it say that the full protections of this statute are reserved for customers who make their own investment decisions, but not for customers who rely upon financial advisors. And if you analyze the economics of what the SEC is suggesting, instead of protecting investors, which is what we as taxpayers fund them to do, they are protecting the industry-funded insurance company, because the vast majority of Americans don't make their own investment decisions. My clients are in their 70s, 80s, and 90s. They don't have the capacity to decide whether they should buy something one day and sell it the next day. They hire financial advisors and they go to brokers who make those decisions for them. They invest through Fidelity or Vanguard and they buy funds, and those fund managers make investment decisions for them.
Is it your view that if this interpretation were held up, and this was the SEC's interpretation throughout, that it would seem to me that millions of investors who just give a more general parameter of investment authority to an investment house may not be covered by a failed account, a failed broker who the SIPC steps in on?
Precisely, they wouldn't be covered for the full 500,000. And the purpose of the statute was to instill confidence in the capital markets. If the FDIC tomorrow, in the next bank liquidation, decided, you know what, we don't insure the accounts except for the net investment, so we're eliminating all interest that may have accumulated over the last 30 years, and we're only going to pay the net deposit, there would be a run on the banking system. And the SEC's filing yesterday for this committee could create a run on the securities firms, because no investor in this country has any idea what kind of coverage they have in the event that they're dealing with a dishonest broker.
Professor Coffey, you had a comment about zero-sum game would be changed if the SIPC assessed its members to provide for the coverage. You made I agree with your comment that it's illusory in the amount of actual cash in the bank.
You are raising the statute.
Would you say, sir?
I congratulate this committee because you are raising the assessment from 150 to 0.2%.
Well, it seems to me, Professor Coffey, that one of the problems here is there's a certain amount of money, and we're sort of backing our coverage into that amount of money, as opposed to creating.
It's underfunded. You're quite right.
Right. The law is the law, and if it happens to be underfunded, then there ought to be an assessment or some way of making the people whole. Not say, well, it's not $500,000 because we don't have enough cash in the bank to make this thing whole. And again, I just go back to how important it is, how strategic and essential it is for the public to know that if they invest, that the money, there is a fund there to protect them if there's fraud, insolvency, and those things out there.
I think you're quite right. I want to make one little comment. To the extent that you raise the amount of assessment that the brokerage industry has to pay, you will also give them an incentive through organizations like FINRA to cut back on risky behavior by brokerage firms such as Mr. Madoff. Right now, they have no interest in stopping Mr. Madoff from being a cowboy and doing what he's doing. But if they have to pay higher assessments and the prospect of higher payouts will raise those, then they'll have an interest in controlling the outliers within the brokerage community.
Right. And Mr. Chairman, just to conclude, again, my view of this is let's follow the law. If the protection is there, the $500,000 protection is there, those people should be given that full $500,000. The clawback, we've already been through this discussion. Nobody's looking for $8 to $10 million back, and if they are, it's not reasonable. But the SIPC has a responsibility, and the SEC has a responsibility to make sure the law is followed correctly.
May I make one response to something Mr. Klein said?
I think we're going to hold because Mr. Klein already did run off,
Okay,
and we allowed that courtesy. But we want to get Mr. Perlmutter in, so just hold. Maybe he'll come to you with a question. Mr. Perlmutter?
Thank you, Mr. Chairman. And I'd like to start with Mr. Green. He has had his hand up a couple times, so if you, sir, would sort of share what you were going to share, and then I'll launch into my tirade.
Thank you, Mr. Perlmutter. I wanted to comment, well, two things. One is I wanted to acknowledge, because at the beginning of my remarks I did not comment that I was a lawyer, so I just wanted to comment that I'll participate, though I did not before, as a lawyer in the dialogue. In this discussion about how decisions will be made, Mr. Chairman, you raised the issue that some tough choices are going to have to be made. And I would like to, again, try and focus on some of the prior policy considerations, public policy considerations, particularly embodied in ERISA. ERISA was created as one of the three legs of the stool to promote the retirement savings of the average American worker, the other one being individual savings, Social Security, and qualified plans. The concept of qualified plans was, the public policy was to encourage employers to create plans to put funds into retirement instead of having profit-sharing funds go at the end of the year just into dollars for workers to spend. There was a keen observation by Congress that workers were not saving those funds for retirement. And so incentives were created that there be qualified funds that they be put into retirement. The type of fund we have is known as an eligible individual account fund, which means that for each participant there has to be an individual account that has to provide for individual accounting of income, individual accounting for expenses. The only purpose for which it is aggregated is for investment purpose. It's an administrative requirement, and it is for that reason alone that the investments go in the name of the trustee. Now the consequence, because we have talked about consequences of decisions that will be made by this committee and by Congress on this issue. If, in fact, we undercut the confidence in ERISA qualified plans because we do not extend SIPC protection to them, then we will discourage the confidence of employers of putting those funds into the qualified plans. Will instead encourage them to give them directly to the workers, which is phenomenal for those employers who do profit sharing like that, but it undermines...
So let me ask you a question on that then. So for each person in the plan, you think there should be $500,000 in insurance?
What I would say is for each participant, there ought to be coverage for the plan up to the account for each individual, subject to whatever the SIPC limit is. Now,
okay, so under today's SIPC levels, it would be up to $500,000 per person in the plan.
Now, I am not going to comment on the net equity issue. I'm not qualified to do that.
Right. And that's
yes.
okay. Let me just, and then I have some questions for Ms. Langford.
Yes.
Just so you all understand my background, I represented bankruptcy trustees in Ponzi schemes. okay? And I represented investors who were victimized and who were either had received more than they'd put in, had invested $100,000, got $50,000 back, but other people only got, got zero back. So, I mean, I understand where Mr. Coffey's coming from and some of his comments. And so what I'm trying to figure out is going back to those three things that I brought up earlier, okay? Bankruptcy, how far and who should be subject to the clawback? SIPC, how far should the insurance reach? So in my state and in my area, I have the indirect investors that Mr. Leveton has talked about, who didn't know Madoff, they didn't know Petters, they didn't know any of these guys. They invested through a fund that then invested in these particular entities. How far should the SIPC insurance reach? I mean, that's the policy decision we've got to make. And then tax-wise, when can somebody take a loss? Can you take those illusory gains and get a net operating loss carryback so that might give you at least some recovery? Those are the three big policy questions I have. But I also am just interested, like Ms. Langford, how did you get into the Madoff network?
How I got in was by looking for a vehicle to. I had just sold my house, and it was my retirement. And I asked a friend, and I said, I want something, safe, liquid, and diversified. And he said, hands down, this is the safest place you can put your money. So I entered into it that way.
So you were a direct investor with Madoff, or
No,
did you come
indirect.
through something else?
It was indirect. It was a partnership, and limited partnership, and so technically it wasn't a technically retirement account, but it was my retirement money.
Okay, thank you. And I just one more point to Mr. Coffey's statement. Mr. Kanjorski's bill that we're going to hear today and tomorrow and Friday does, I think at a $10 million level, separate custodial accounts from investment advisor accounts to try to separate those things so that somebody isn't posting you phony statements and advising you at the same time. Or I hopefully that kind of separation will work as you've suggested.
Thank you very much, Mr. Perlmutter. We're at the point we're waiting for the House to go back into session, at which time we'll have 3 votes. Certainly, rather than tie this panel up with any further questions, what my intention is to dismiss the panel. And thank you very much for your examination. And then to stand in recess until 30 minutes after the call of the next vote. So we anticipate that the call may occur within the next 10 to 15 minutes, and then the return to take the second panel 30 minutes after that call. Without any other further comments or objections, the committee will stand in recess. This hearing come to order. I'm pleased to welcome our second panel. But before I introduce members of the panel, may I caution the audience that it is against the rules of the House to have demonstrations of emotions. We understand how feelings run high, but we would appreciate that you extend the same courtesy to the witnesses in this second panel as you did to the witnesses in the first panel, with the absence of cheering. And that being said, we'll address it no more. And now I'm pleased to first recognize Mr. Michael Conley, Deputy Solicitor for the Securities and Exchange Commission. Mr. Conley.
Chairman Kanjorski, Ranking Member Garrett, and members of the subcommittee, thank you for the opportunity to appear before you today on behalf of the Securities and Exchange Commission. My name is Michael Conley, and I am the SEC's Deputy Solicitor. There are a number of issues being discussed here today, but I wish to focus my limited time on explaining the Commission's views regarding the SIPC liquidation of Bernard Madoff's securities firm. We at the SEC are keenly aware of the devastating losses incurred by the thousands of investors who entrusted their money to Madoff. Many, if not most, of his victims have had their lives upended.